Medical Patent Law TED Talk by Maggie Barnard. What is patent law? A patent is a form of intellectual property that gives its owner the legal right to exclude others from making, using, selling, and importing an invention for a limited period of years in exchange for publishing and enabling public disclosure of the invention. Patent law and copyright law go hand in hand with each other, which is very helpful because they are very similar. But traditional patents protect tangible scientific inventions such as circuit boards, car engines, heating coils, or zippers. However, over time, patents have been used to protect a broader variety of inventions, such as coding algorithms, business practices, or genetically modified organisms such as a tomato. While both patents and copyrights are used within the medical field, a copyright law usually protects works in literature, music, and art and software, unlike a patent which protects inventions and processes. What is medical patent law? Medical patent law is a legal protection against market competition that a government grants to the inventor of a unique medical item or process. Medical patents will be defined broadly to include patents that relate to pharmaceuticals, methods of making and using them, medical treatment regimens, surgical procedures, medical devices, healthcare information technology for hospital and healthcare management systems. How the government protects a patentee from getting their invention stolen is usually a patent provides the patentee a unique marketing advantage for their invention, as others are prevented from utilizing any aspect of patented subject material unless a license or other right to use is conveyed by a legal court or a lawyer. History of medical patent law. Patent medicines originally referred to medications which ingredients had been granted by the government for protection. But actually, recipes in the 19th century patent medicines were not officially patented. Most procedures used ingredients quite similar to their competitors, meaning market competition protection from the government was barely there. Since the government couldn't control what patented ingredients go in what medicines, there was almost no regulation on the ingredients. The medicines were questionable and the effectiveness of whose contents were usually kept a secret. Back in 19th century England, medicine wasn't usually sold by only doctors. The medicines were sold by postmasters, goldsmiths, grocers, tailors, and other local merchants. People would sell it using different price point advantages, trying to avoid patents, which weren't really held accountable for by the government. Now, in the middle of the 19th century in America, medicine was becoming a major industry, often high in alcoholic content, but these remedies were very popular with those who found the ingredient to be therapeutic. Later on, a lot of physicians and some medical societies were being very critical of some of the existing patented medicines. They argued that some of the remedies did not cure illness due to their high alcoholic content, and were discouraging the sick from seeking these legitimate treatments that cause alcohol and drug dependency. In 1881, the Proprietary Association was founded, which is a trademark association of medicine producers. The association was aided by the press, which had grown dependent on the money received by the remedy advertising, just like the people had been growing dependent on drugs and alcohol. The pivotal event occurred when North Dakota passed a limited disclosure law, which included patent medicines. This association voted to remove their advertisements from all state newspapers. With strong support from our president at the time, Theodore Roosevelt, a Pure and Drug Food Act was passed by Congress in 1906. 5 Supreme Court cases related to medical patent law. The first Supreme Court case I'll go over is called Teva Pharmaceuticals USA versus Sandoz Incorporated. Sandoz Incorporated submitted an abbreviated new drug application, also known as an ANDAS, to Food and Drug Administration, otherwise known as the FDA, to produce and market a generic version of Copaxone. Copaxone is a drug used to treat multiple sclerosis, and it is manufactured by Teva Pharmaceuticals, who owns the patent rights for the drug. Now, Teva Pharmaceuticals sued Sandoz using 2 different types of claims that are based on different ways to use molecular weight to distinguish between polymer samples. The district court did not distinguish between the different methods of using molecular weight and held that the claims were not indefinite, as Sandoz argued. The district court held that Sandoz products infringed on Teva's patent due to how similar the drugs were, not only in the molecular weight but the actual polymer samples. The ruling in this case ended up being a 7-2, which was in favor of Teva Pharmaceuticals. The second case I'll be going over is called Helsinn Healthcare SA versus Teva Pharmaceuticals USA Incorporated. This case occurred in 2019 when Helsinn sued for patent infringement. Helsinn made a treatment for a chemotherapy-induced nausea drug. While developing this product, Helsinn granted another company the right to market a 0.25 milligram dose of palonostrone in the United States. The company was required to keep the proprietary information confidential. In 2003, Helsinn filed a provisional patent application covering the 2.5 milligram dose. Helsinn also later on filed 4 patent applications that claim the priority to the 2003 date. In the 4th application, filed in 2003, it is covered by the AIA. In 2011, Teva sought approval to market the generic dosage of the product. Teva later on countered that the 219 patent, otherwise known as the 4th application that Helsinn filed in 2013, was invalid under the on-sale provision of the AIA, which precludes a person from obtaining a patent on the invention that was in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. Also arguing that the dosage was on sale more than a year before Helsinn filed under the 2003 application. The Supreme Court ruling was unanimous, but the case is also currently still pending due to that it did occur in 2019. The third case I'll be talking about is the Mayo Clinic versus the Prometheus Laboratories Incorporated. Prometheus Laboratories Incorporated patented the steps for testing for proper dosages of drug treatments used to treat GI diseases like Crohn's disease, and later on sued the Mayo Clinic when the Mayo Clinic attempted to use its own similar test. A federal judge invalidated the patents, holding that a patent couldn't cover the body's reaction to the drugs. The U.S. Courts of Appeals for the Federal Circuit, which specializes in patent issues, overturned the lower court order. The main question in this case was, can certain types of diagnostic medical tests be patented? The Supreme Court ruled this case in a 9-0 decision, all in favor of the Mayo Clinic. The fourth case I'll be talking about is MedImmune Incorporated versus Genentech Incorporated. The question is, does the actual controversy requirement of the Declaratory Judge Act require that a patent licensee break its licensing agreement by refusing to pay royalties before suing to declare a patent invalid and unenforceable? Genentech held that the patent for Kebili 1, a process for using cell cultures to manufacture human antibodies. MedImmune had a licensing agreement with Genentech under which MedImmune paid royalties to Genentech in return for using the patent. Later, Genentech also obtained the patent to Kabili-2, a continuation of Kabili-1 process. Under the licensing agreement, MedImmune became a licensee for Kabili-2 as well. Genentech informed MedImmune that it would have to pay royalties on one of its most lucrative products, Synagis, which uses Kabili-2 process. MedImmune sued Genentech, claiming that the patent was invalid and unenforceable. However, MedImmune kept paying the royalties. This was an 8-1 decision in favor of MedImmune. A lot of the time, Supreme Court case rulings in pharmaceutical matters or medical patents usually affect small pharmaceuticals and how they run and operate their business, especially in our competitive market. In most cases ruled by the Supreme Court, they are ruled in favor of the company of the original patent, but unless the patentee breaks the patent or even gives away the product information in what they call confidentiality, they can still get their patent rejected or sometimes taken away in order to allow for more market competition within the industry. Thank you for listening to my presentation on medical patent law. I hope that I was clear with the history and the general basis of what medical law is and how it relates to patents. Thank you.